Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below.
If I am attempting to have USCIS waive my 3-year or 10-year bar, due to unlawful presence in the United States, can I depart the United States with a pending provisional waiver application, using Form I-601A?
Let's take a look. The provisional waiver, also known as the stateside waiver, is a waiver authorized by law to waive the 3 or 10-year bar against a non-citizen from seeking an immigration benefit, resulting from a non-citizen living in the United States, without status for a certain period of time. The 3-year bar applies when the non-citizen lives in the United States for more than 6 months, but less than 1 year. While the 10-year bar applies when the non-citizen resides in the United States for more than 1 year. Either bar activates after departure from the United States. Immigration law allows for a waiver of the 3 or 10-year bar if the non-citizen seeking a green card has a qualifying relative, who is a parent or spouse, who is either a U.S. citizen or legal permanent resident, who will suffer what is called extreme hardship if the non-citizen green card beneficiary is not allowed to return to the United States. The stateside waiver allows for the green card beneficiary to apply for the waiver while present in the United States. The theory behind the stateside waiver process is to avoid the harm to U.S. citizens or legal permanent residents caused by separation from the green card beneficiary, while waiting approval of the waiver from outside the United States. One of the limitations of the stateside waiver is that the green card beneficiary must wait in the United States throughout the entire time it takes for USCIS to process and approve the waiver. Therefore, if the green card beneficiary departs from the United States at any point prior to approval of the waiver will be denied, requiring the green card beneficiary to start a new waiver application process from outside the United States. As a result, if the green card beneficiary invested several months waiting for processing of the stateside waiver, departing the United States will result in the denial of the waiver, and requiring the green card beneficiary to process through the consular interview process. This requires a new application for the waiver, after the interview from the U.S. consulate abroad. Since there are currently significant delays for the scheduling of the consular interview, the wait abroad can hit many months to well over a year. Review personal circumstances to consider filing for the waiver from outside the United States. Before applying for the stateside waiver, the green card beneficiary should consider whether he may be required to return to his country within the next 2 to 3 years. This is the current processing times for the stateside waiver. If such travel is likely, then the green card beneficiary may want to consider holding off on applying for the waiver until departure. However, as indicated, the problem with departing before the stateside waiver is approved is that the green card beneficiary must wait for the scheduling of the interview, which may take months to well over the year. They must then wait for the processing of the waiver, which may take another year. Although the choice between applying for the stateside waiver or the waiver from abroad is a personal decision, dependent on personal circumstances, an experienced immigration attorney can help in making such a difficult decision by advising of the pros and cons of both options, and to also explore other potential options to applying for the green card without departing the United States. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.